heard appeals in the matter of JP Morgan International and Realize.com Limited.
Morning, my lords. As regards the sequence for the remaining part of our submissions, I will, if I may, with your leave, come directly to answer my Lord Justice Lewison's question of yesterday afternoon. Secondly, I will then finish off our third ground on our main submissions, then come to our fourth and final ground, and then the conclusion, and I'm done. Starting with my Lord Justice Lewison's question, may I just read into the record for your later convenience in reading the transcripts the question now, which appears in day 2, page 183, lines 6 to 12. My Lord said, a lot of your submissions have been on the basis that the judge decided that the expert should ignore Regulation K. Therefore, the declaration served no useful purpose. It was inconsistent with her judgment to make the declaration, and so on. What if she was wrong about Regulation K and its impact, or potential impact on the valuation? My Lords, I have a short answer and a long answer to my Lord's question. The short answer is this, that the declaration, in those circumstances that my Lord posits, would still likely serve no useful purpose. And the declaration would still have, in any event, been inappropriate in light of the other points that we make beyond the utility argument in our submissions. So that's our direct answer. The long answer, well, accordingly, we say that WRL's appeal should be allowed on the declaration issue, notwithstanding that factual matrix that my Lord put to me eventuating, including on the basis that the declaration serves no useful purpose, even if you allow JPM's appeal on the valuation dispute. The long answer goes thus. The question my Lord put to me, if I may be so impertinent to rephrase it, is whether the declaration would still serve a useful purpose if JPM's appeal on the valuation issue were successful. And the answer in developed form for present purposes would depend on how and why the court allowed JPM's appeal. As you know, the appeal by JP Morgan on the valuation dispute comprises 3 sub-issues, and I will take each of them as potential bases for this notional decision in turn. May I invite you to have before you, please, core bundle, page 65.
65.
Page 65, yes please. It's it's tab 2B Roman 3, page 65.
Yep.
As a reference point, I hope it helps to take things more speedily having that in front of you. As you will see in 1.1, 1.2 and 1.3, JP Morgan set out the 3 alternative bases upon which they bring their appeal on what I'll call, for these purposes, the valuation issues. I'll take each in turn as I say. As regards ground 1.1, this is JP Morgan's argument that the projected financial performance of Viva, pursuant to 3.6a of Schedule 1, which we've dwelt on so much, means projects contained in or consistent with Viva's current approved business plan.
Yeah.
If JPM is right on this point, my lords, then the declaration has no utility. The status of Viva as a subsidiary has no bearing on what the current approved business plan already provides, or, perhaps more pertinently, does not provide. More particularly, the relevance of ground 1.1 is that the current approved business plan does not provide for Viva to undertake activity in the US. Automatically in our submission, the declaration would have no bearing on this point. The second basis upon which they put their appeal is ground 1.2. That I summarise as JP Morgan's argument that fresh financial projections must be consistent with the current approved business plan. If JP Morgan is right on that point, then the declaration still has no utility. The status of
the same reason as you just given.
precisely. Moving on, the third ground, 1.3, namely JP Morgan's argument that when valuing Viva, the valuation experts should not disregard obligations, restrictions or limitations of Regulation K, which arise by virtue of JPM's shareholding in Viva. Again, we say repetitively, but I hope appropriately, the declaration still has no utility, but the reasoning here is a little more involved. First, the valuation experts would still be entitled to proceed on the basis Regulation K currently applies. That is the current position or status quo because of the obligation in paragraph 3 of Part B of Schedule 15 that you've already looked at. A declaration that Viva is a subsidiary does not assist in that case. Further, and as my learned friend Mr. Handyside was at pains to emphasise, the valuation experts would still be entitled to proceed on the basis that Regulation K may not apply in the future if Viva was sold to a third party that was not an edge corporation. In that case, knowing whether Viva is presently a subsidiary of Viva is of JP Morgan is of no assistance. Secondly, even if the court is not with us on those points, this remains to be said. The declaration does not serve a useful purpose, my lords, because it does not answer the critical question of US law, which the experts need to know to take into account Regulation K restrictions in any event, namely, what those restrictions are. What can Viva do in the US? This point was, if I may respectfully say so, best put to me yesterday by my Lord Justice Snowden, when my Lord said to me, day 2, page 171 to 172, the fact that it is a subsidiary for the purposes of the regulation, in a sense, just gets it into the regulation. I mean, on the contrary, if it had been held it is not, it would be out. The declaration doesn't go into any of the consequences, it just deals with the are you or are you not a subsidiary. We respectfully agree and adopt what my Lord said yesterday. The declaration does not resolve the dispute and consequently does not serve a useful purpose, because all it establishes is, as you know, that Viva is a subsidiary of JPM for the purposes of Regulation K, thus bringing it within Regulation K. It does not, for example, assist the valuation experts with the question of whether the FRB would authorise activities under Regulation K which would otherwise not be permitted. The question of whether Viva is allowed to conduct these activities is the only question that matters for the valuers. A finding that Viva is a subsidiary of JP Morgan for the purposes of Regulation K is thus but the start of the question, end of it, as I submitted yesterday. Accordingly, the unadorned declaration, in the terms fashioned by the judge or anything similar, adds nothing over and above the judge's findings in the judgment. So that is our answer, dealing with each sub-issue in the valuation dispute in turn. And continuing the long answer, I'd just like to make two last points. First, the reality remains this. There is plainly utility in a finding of fact between the parties to the SHA that Viva is a subsidiary. JPM have that, it is not appealed. The question is what would be added by a declaration. If I may repeat what I said yesterday, day 2, page 129, lines 2 to 5, Viva was not and is not a subsidiary, unless and until the Fed says otherwise. As things stand, it does not, and therefore the declaration is premised upon a falsehood. The concept of utility is not free-floating. It must be measured against reality. And the reality here would still be that the declaration would be given in a bubble that is unreal. Second and last point, and here I finish. All the other points we make on this part of the appeal would be entirely unaffected by the factual premise that backed my Lord Justice Lewison's question to me of late yesterday, which I'm here answering. None of them turn on or even relate to the issue of contractual construction encapsulated in the valuation dispute. As you know very well, Those are Viva's absence, or not to be given because inappropriate, not to be granted because of the FRB's potential involvement already. And therefore, that is the end of my answer in long form to my Lord's question.
Thank you.
May I return to where I was in our submissions, which is in my third complaint, inappropriate, for the judge to grant the declaration, and finish my submissions on that ground by making these short points. May I start this morning's substantive submission by explaining what we say inappropriate means in this context, why we say it was inappropriate to grant the declaration. And may I emphasize 5 connected points of background. First, the FRB is a highly specialized regulator. Secondly, and as we say in paragraph 64 of our skeleton, the issue of whether Viva is a subsidiary of JP Morgan with the meaning of Regulation K is within the exclusive competence of the Federal Reserve. JP Morgan argue at paragraph 77 of their skeleton, and my learned friend may well give airtime to this when he replies, we'll see, say that it is wrong to say that the interpretation and application of Regulation K is within the competence of the Federal Reserve because it is non-justiciable. That is, if I may say so, an uncharacteristic but obvious misunderstanding of the point that we make.
Where do we get the information or finding that the question whether Viva as a subsidiary is within the exclusive competence of the FRB?
It's within the expert evidence of the that was laid at trial.
Right. Have you got any references for
No,
that?
but I'll find one. This will be heard by Mr. Lau, Mr. Redmond, not least remotely, and they will find the appropriate references.
But I thought you accepted yesterday that, for example, that decision could be challenged by judicial
Yes,
review in the courts, so that the courts in the US have jurisdiction to determine the question.
No, well, no, forgive me. I accepted yesterday, and I was about to come to repeat the acceptance now, that we accept that the exclusivity to which I advert is a practical one, and that technically the decisions of the FRB are amenable to judicial review in the United States. I accept that. Whether in fact, and there's no evidence about this, about what the judicial review position is in the US, but assuming for one moment, if it's not too grand a leap, that the position in the US and the position in the UK correlate. One wonders whether this decision, to pick up on the point that my Lord just put to me, this declaration of this sort would be reviewable. It would be reviewable, I suppose, if there was some procedural irregularity or impropriety to which could be pointed that would condemn the decision given notionally now by the Fed as to the subsidiary status of Viva under Regulation K.
But as I understand it, I mean, at this point I sort of put you in, we were directed to the paragraphs in the judgment, I think around about 161 to 164. There is a test for what a subsidiary is for the purposes of the Edge Act, or for the relevant purposes.
Yeah.
There's a test.
Yes.
Just like there's a test for what is a subsidiary in this country.
Yes.
So it's not really a sort of a question of discretion for the regulator. I mean, they are the person who enforces, no doubt. But at the end of the day, it's just a legal question. Are they or are they not a subsidiary?
Yes, but their decision made as regards the subsidiary status would only be challengeable by judicial review, whereas in this country on certain very narrow grounds.
Yeah.
And as my Lord knows so much better than I do, it is often said by courts when faced with a challenge to a decision of a regulator that an entity doesn't like, well, we the courts are going to give a wide margin of discretion to the enforcing body and regulator to ensure that we don't trample across its ground, whether it is bringing a prosecution by the SFO, failing to bring a prosecution by any prosecuting body, regulatory action, failure to regulatory action. We have experience, my Lord, superior to mine, of attempts to argue points such as this, and they in the end, they founder or succeed, usually, on procedural or very rarely on substantive grounds.
Well, I'm not so sure about that. If the complaint made about the regulator is that it's misconstrued the statute under which it is operating, the court can say so.
Of course it can. Then it would be a sort of substantive, one of those rare examples of a substantive situation in which a regulator has gone sufficiently wrong to be overturned on a judicial review. But, my Lord, in this case, we have the fact, without being wearisome, just to respectfully remind you, not a single case pointed to of a challenge to rate the FRB's decisions as a regulator. A rule of very long standing of many years, with no body of reported decision making even by the regulator itself that is openly accessible to the outside world.
But it's not a situation, as my Lord put to you a moment ago, where, for example, there's a discretion in the regulator which could be exercised in one of two ways, and, for example, there's a long history of it being exercised in a particular way. Then you can understand why interference by the English court would be regarded as inappropriate, because it would be, as it were, trampling on the discretion of the US regulator. But this is not, we're not in that situation. What we're in is a situation where there are definitions of subsidiary set out in paragraph 148, definitions of equity set out, I think, at 161, and then the judge, and expert evidence both ways, and the judge simply prefers Mr. Newell to Professor Orrery.
Yes.
On the basis that you could effectively, that Viva could be a subsidiary of JP Morgan because you take into account not only the current shareholding, but what the shareholding would be if it exercised the option. And he makes the point that you could be, in fact, be a subsidiary of two companies under that particular provision. And it's simply an interpretation by United States lawyers of a piece of legislation. It's got nothing to do with the regulator as such. It's not the regulator which is, as it were, analysing the definition in some way that's discretionary.
Well, Lord, I understand exactly the point that my Lord puts to me, and if I may say, as far as it goes, it's obviously correct. But 2 points. One, we're dealing here with a UK court's interpretation of a US regulator's likely approach to a US regulation.
Well, no, so that's where I think we expect all three of us sort of parting company with you. The declaration does not say anything about the Fed. It simply says it either is or isn't a subsidiary for the purposes of Regulation K. It says nothing about how the Fed should approach it, what decisions the Fed should make on how to implement Regulation K, or anything at all about that. It
doesn't say this is how the Fed will interpret Regulation K.
It actually just,
because that wasn't the evidence. The evidence was, what does Regulation K mean out of US law?
But the offence that, if I put it this way, that we find with the analysis that says it was permissible for the judge to arrive at this conclusion is that the whole area, we respectfully submit, is not for the UK courts to intermingle with. It is for the regulator in the US, i.e. the Fed, to deal with. And it is for the Fed to determine the answer to the question, not the English commercial court. And there is a decoupling here of decision from reality, in that the decision of the English court is premised upon, if it means anything, it's only worth it if it happens to accord with the actual view expressed by the Fed. If the Fed came to the same conclusion, supposing one had a situation in which is unlikely, I know, but we have a concurrence and a congruence between a decision of the Federal Reserve stating that Viva is a subsidiary for the purpose of Reg K and the English court, fine. But we don't have that. What we have is we have no decision from the Fed, who, as I shall come to in my fourth ground, could and may have been approached, ironically, by JP Morgan already. We don't know because of their shyness to answer the question. I'll come back to this in a second. And the declaration by the English court as to what it thinks, are based on the expert evidence, the regulation means. And in our submission, that is certainly something that is offensive, but my repeating the point probably won't make any difference.
I understand your previous point, which is, and I paraphrase, not as elegantly as you put it, why does it matter for the purposes of activating or implementing the call option mechanism whether Viva is currently a subsidiary or not?
Mhm.
Because you say it doesn't matter because the call option is looking either at what's currently done, which is a fact, or what might be done by a purchaser in the open market,
Yes.
who will have their own view about whether they are subject to regulation K or not.
Yes.
So I understand that point, but if you're wrong on that and there is a purpose, because I think you're taking your grounds not in merit but sequentially anyway, if it did matter for the purposes of operation of the call option, whether JP Morgan, whether Viva was a subsidiary of JP Morgan for regulation K purposes, so on that assumption, the declaration serves a purpose between the parties in terms and the people who are required to operate the call option. It won't have any effect on the Fed, but in a sense, who cares? Because the Fed isn't interested per se in what the call option value is either. And so, in a sense, the offence that you suggest is going to be caused to the Fed, who is a sophisticated body and can frankly take its own view, is a bit of an illusion, isn't it?
Well, the illusion is in the value of the declaration.
Yeah, but that was your
Yes.
prior point. And as I say, I'm taking your point sequentially.
Right.
So if you're wrong on your prior point,
Yes.
such that there is some purpose between the parties and those who have to implement this call option to know the answer, the English court can hear the expert evidence and give the answer.
It can, subject to the fact that Viva is, of course, affected by its status is determined by the nature of the declaration without being heard, not a party to proceedings.
Well, that's a separate point.
It is.
And I'm not sure it is. I mean, Viva's status, as you've pointed out many times now, in the US is not going to be affected by the declaration because the Fed will make its mind up as to what the position is in the States. You've asserted that the Greek regulator might get terribly confused about the status of this, and I've yet to see any evidence of that, but you would have thought the Greek regulator would, if you're right, check with the Fed rather than get confused by the English court judgment. So what's the problem?
Well, the problem is that it creates a wholly unlooked for confusion, and that the correct answer is, from the English court, ought to be to say, these are the facts I find, not appealed, as my lords pointed out to me yesterday. Should I grant a declaration? Look at the facts. Answer no. Go and ask the Fed. That should be the answer. Why introduce an extra tier of complexity merely because JP Morgan appears to come to ask the English court for it to hear expert evidence on a US law point to determine what the English court thinks?
But if it matters to the parties and the operation of the call option, being told, notwithstanding that the English court has reached findings of fact which it could declare, oh, I'm not going to do so to bind the parties to the call option, go and talk to the Fed, is really not helpful, is it? The parties need to know and have a declaration which binds them in the operation of the call option.
Can we test it in this way? It's a point I was going to come to later, but I'll raise it now. Imagine this situation, which is not impossible, that the English court grants the declaration that it does inter partes between WRL and JP Morgan as per clause 5 of the order. The Fed get asked for their view and come to the contrary view. Where that leaves everyone would be in a muddle in our submission.
Well, that's going to happen anyway, because you haven't sought to appeal the fact the judge made the findings of fact, which he did. And forget the declaration for the moment. If somebody goes and asks the Fed and Fed says, no, it's not a subsidiary, English judge is completely wrong, then there's going to be that same level of confusion, isn't there?
Well, no, with respect, there isn't, because what is made is For the first stage would be the finding of facts, as my lord just put to me, would be there in any event.
Which would be binding as between the parties
Yes,
who were before the court and who fought the issue. Never mind about Viva, but it would bind these two parties, whatever the Fed says.
but no party will, I would suggest, seek, if we ended up in a situation where the Fed reached a contrary position, then the parties would not seek to maintain the correctness of the factual findings, I would suggest.
Well, I don't know.
But what would be better qualitatively is there is a leap from the findings of fact being still extant and a matter for debate between the parties and the courts, if that should ever eventuate, and a declaration of the in rem status, forgive me, my lord, repeating it again, but the in rem status of Viva, enshrined in paragraph 5, which stands starkly alongside and abuts a finding by the regulators to the contrary, that as a matter of US law, it's not a subsidiary. And so, my lords, that would be a very uncomfortable position for the parties and the courts to be left in. And the remedy lies in what we say the judge should have done with greatest of respect, i.e. make all the findings of fact that the court wished, fine, and having made those findings of fact, stop there, because on applying the principles that I've wearied my lords with more than once, and I won't do it again, we submit that this is not an appropriate declaration.
Yep.
May I move to the fourth and last ground, please, which lends into the debate that we've just been having. It was common ground that JP Morgan could have simply asked the Fed for the answer if they wanted to.
So could you, presumably.
Yes. There is presently a dialogue between Viva and the Fed.
Now, either party to this action could have asked the Fed.
Only
So
the
could Viva.
I'm so sorry, I spoke across.
So could Viva.
Yes, but you remember I laid out, of course you remember, a three-stage process which governed the approach to the Fed, and you remember the first basis would be an informal approach. Yes, anyone can do that. A request of an advisory opinion, which is what has been asked for by Viva.
They can ask for the full Monty.
No, they can't ask for the full Monty because only an edge corporation can apply for the full Monty.
Okay, so they can go, right, so they've asked as much as they can get.
Yes. And can I just, in case anyone wants references to this, the informal approach in the trial bundle is B/7/7, so B tab 7, page 7. The advisory opinion, F.
Give that reference again.
I'm so sorry, B/7/7. And it's in JP Morgan's voluntary further particulars, paragraph 9.3b. The advisory opinion, under which any person can seek an advisory opinion regarding the scope of activities permissible under any subpart of this part, which my lords may think is the thing that matters, under any part of Regulation K, is something you ask for under the endless numbering, forgive me, they're not my fault, 211, spot 11, brackets A of Regulation K, which in the reference in the trial bundle is F 17, 19 to 20, and F 29, 39.
Sorry, is that an appeal bundle reference?
No, those are the trial bundle references. In case I don't think any of this is in dispute. And the third basis is the approval application. This is my lord's full Monty. But as I said yesterday, and I think I'm still right on to say this, an edge corporation, not anybody, but an edge corporation can apply for approval pre an undertaking or authorization after a particular investment has been undertaken, pursuant to section 211.10c of Regulation K. Trial bundle reference F 1719 and F 2939, or under section 211.6b of Regulation K, F 17 page 11 or F 29 page 35. And so the full Monty is accessible only to one of the participants in the dance, and that is JP Morgan. It's open to Viva, which is engaged, or WRL, or any other person to go for the half Monty. If there is, I'm not sure there is such a thing, but my Lord knows what I mean. So as I was saying, it is common ground that JP Morgan could have simply asked the Fed if they wanted to. And JP Morgan must be borne in mind are the largest bank in the world, I think, by capitalization. They are a major player in the financial markets in the United States, of major significance in the financial structures, something of a behemoth in that field. And one doesn't want to speculate idly, but it is interesting they haven't apparently asked, I'll come back to that, what their own regulator thinks.
Your clients are not short of a bob or two either.
No.
I mean, I appreciate they're not American, but on the other hand, is there anything to stop them seeking the second option?
No, Viva are doing that.
And could have done in front of, at the time the matter was heard by the judge.
Well, bearing in mind that Viva were not a party to the action, WRL's position was incontestably from the first, this is not an issue that should have been to result in the expedited trial anyway. And some months ago, I have to be careful how far I go on this, there's correspondence with JP Morgan solicitors and those instructing me on this at the moment. This is happening in real time, parallel with this appeal. Viva have some months ago started a dialogue with the Fed, but it's a dialogue that is advisory only and may or may not bear any fruit. But what is so odd about the situation that we find ourselves in our respectful submission, is that we should be having this debate at all. JP Morgan say in their skeleton argument that it makes no difference whether JP Morgan could have asked the Fed how Regulation K applied, paragraph 81. The judge was entitled at least to grant the declaration where there was no evidence from the Fed, and despite the fact that the approach to the Fed could or would have resolved all or some of the US law issues once and for all, paragraph 82. Our Part 18 application ought to be disregarded, 82.1, and CSI, confidential, sensitive information provisions, prevented JPM saying more than they did. This all started in a very odd way right at the end of the trial. The question which WRL wanted an answer to is this: has JP Morgan discussed Viva's status under Regulation K with the FRB, and if so, when? And that was then enshrined in the Part 18 request, supplementary bundle, tab 35, page 294. You can trouble you to turn to it. The question has, I respectfully submit, an obvious significance to which I'll return in a moment. And as you know, what transpired led to our making a formalised Part 18 request at the end of the trial, with which we put a simple question to JP Morgan. It having arisen through my learned friend Mr. Handyside's ending of his, not the very end, towards the very end of his submission, closing his case, the end of what was by any view a very intensive expedited trial, in which he said this, and it's supplementary bundle, tab 29, page 253, and I would like you to turn to that perhaps. Supplementary tab 29.
Page 253, yes.
Yes, 253. Page 168.
Yeah.
Lines 14 to 22.
Right.
So this was his putting to bed, he hoped, my forensic point of why haven't they asked the Fed. It could do nothing of the sort, because they would not say one way or the other whether they had or had not, saying that revealing of any conversation with the Fed would be unlawful under US law because it would constitute confidential supervisory information.
What Mr. Handyside said, and even the fact of its existence to a third party. So in other words, what he's saying is not just the content of the conversation, but even the fact that the conversation took place.
Or even
So
did not.
it's all privileged and they can't, he's saying the CSI privilege means that JP Morgan cannot even tell you whether they've had a conversation with the Fed. That's what's being said.
It is.
Now, if that's not subject of any challenge in this court, why shouldn't we take that as said by Mr. Handyside on instructions? And no doubt if there's no suggestion that it was misleading or wrong, we have to take it at face value, don't we?
We of course have to take the submission perfectly at face value, but obviously behind it sits a degree of advice, because even if somebody of my own friends,
Well, one just doesn't know.
well, what we do know
One
is
just
that
doesn't know. I mean, it may be, and it wouldn't surprise me in the slightest, that the Federal Reserve Board is a bit cagey about allowing things to get out into the open. Some regulators are.
yes, they are.
And there's no evidence to suggest that this is, as it were, a sort of put-up job, if I can put it that way.
I'm not suggesting that it is a put-up job, but I think that the suggestion goes so far as to say that if there was not only a conversation that is covered by CSI, but even the fact that there wasn't a conversation is covered by CSI. In other words, they can't even deny that something that didn't happen.
Yeah.
Now, my lords, the position that left everyone in was this.
It's neither confirmed nor denied. It's
Yes.
a pretty familiar formula for
One's heard it
dealings with
before.
certain government departments in a number of jurisdictions, including this one.
Yes, we know how that often plays out.
Well, never mind how it plays out, Mr. Blessack. The fact is that it's part of the as it were, the regulatory process.
Yes, it is. It is part of the regulatory process.
Okay. All right.
But what we say about this point is this, that the judge was placed, obviously, in a very difficult position. These proceedings have been conducted at breakneck pace, and what I just, without intending any discourtesy, this point arising in the dying seconds of an ordinarily compressed timetable created a problem for the judge to resolve. Given the extent to which the wall was erected through the claim of CSI privilege by JP Morgan, which isn't evidenced, I note in passing, but be that as it may, moving on, we submit that her ladyship should either have resolved the application under Part 18 or declined to grant the declaration. Now, I recognise in the real world potential problems of the submission that I've just made. I know that. But we had here a situation in which there was a complaint made by us repeatedly as to why didn't you ask the Fed. At the very last minute, a point is floated, but I can't give you any detail because it's privileged. So it floats and sits there, just lightly on the surface, hoping that that fish will rise and take the bait. And leaving the judge in the unhappy position of having to deal with a compressed timetable for an expedited trial on many issues, found faced with this at the end. We submit that the obvious significance of it doesn't even really require articulating. And what should have been done is the learned judge should have stopped and said, we either need to resolve this one way or the other, because we didn't accept the CSI assertion, but there's not evidence on either side, so there we are. And what you should not have done is just press on, despite the possibility that in fact the Fed had already been asked. There was no problem in her saying, I want to hear from the Fed on this, I want to explore properly the CSI aspect of this, I want to just take a pull and wait and see what the answer to the situation is. But as I say, I recognise this is very difficult in the circumstances in which they found themselves, the judge found herself. But we respectfully submit that it doesn't provide coverage for just pressing on regardless. So, my lords, may I finish our submissions in much the same place as we started them? I've addressed each of the four individual reasons that we respectfully rely upon, separately and serially. But this does not mean that the judge below was required to, or this court should view them separately or in silos. We respectfully submit that when determining whether the grant of the declaration was appropriate, the court should look at the case in the whole. And when this case is looked at properly in the round, one sees that this was a declaration on an irrelevant hypothetical issue, which even rendered relevant did not pass muster. Without hearing from the subject of the declaration, which sought to predict the approach of a specialist foreign regulator on an issue on which the foreign regulator may have been asked for, may have given or may not, authoritative guidance already. So if you have any questions that my lords have, those are our submissions.
My lords, the issue that arises under this ground of WRL's appeal is whether this court, as an appellate court, should interfere with the exercise of the judge of her discretion, whereby she decided to grant a declaration reflecting her finding of US law made on the basis of independent expert evidence and against which there is no appeal, that Viva is a subsidiary of JP Morgan for Regulation K purposes. In substance, although presented as 4, WRL makes 3 points. First, WRL says that the declaration serves no useful purpose in view of the judge's finding that Schedule 1 requires the valuation experts to disregard Regulation K. Second, WRL says that the declaration should not have been granted in Viva's absence. And third, WRL says that the issue lies within the exclusive competence of the Fed as a foreign regulator, and that JPM could have, or indeed might have, asked the Fed to resolve the dispute. Mr. Lissack began his submissions yesterday by identifying what he referred to as 5 headline points, although by the time he got to the end of his list, the 5 had seamlessly morphed into 6. First, he submitted that whether or not Visa is a subsidiary of JP Morgan for the purposes of Regulation K is a matter of US law, and that Viva is only a subsidiary of JP Morgan for the purposes of Regulation K when the Fed says it is. The first part of that proposition, namely that the question is a matter of US law, is correct. The second part of that proposition, namely that Viva is only a subsidiary of JP Morgan when the Fed says it is wrong. And it may be helpful to identify right at the outset the basis on which the judge concluded that Viva is a subsidiary for the purposes of Regulation K. So can I take you please to the judgment below, paragraph 148, which is on page...
That's where she sets out the definition.
Yeah, so the judge sets out the definition of subsidiary. So just taking you through this. Subsidiary means an organisation that has more than 50% of its voting shares held directly or indirectly, or that otherwise is controlled or capable of being controlled by the investor or an affiliate of the investor under any authority. Among other circumstances, an investor is considered to control an organisation if, and then the relevant one is 2, the investor and its affiliates directly or indirectly own or control more than 50% of the equity of the organisation. Key word there is equity. Equity is defined in Regulation K, as you see from judgment paragraph 161. 161, the definition of equity is as follows. H, equity means an ownership interest in an organisation, whether through, and then 3, any other form of interest conferring ownership rights, including warrants, debt, or any other interests that are convertible into shares. So you can see immediately the option rights convertible into shares.
That was what the opinion of Mr.
I was just going to remind you about that. That's at paragraph 164, where Mr. Newell identified several routes by which one could conclude that Viva was a subsidiary, and the relevant they're underlined by the judge. One of those routes, 2, was where JPM owns or controls more than 50% of the equity of Viva, again appropriately taking into account the additional equity of Viva that JPM may acquire under the call option. So under the call option, JPM has 100% equity interest. Think about it, it's got 49% and it has option rights over 51%. And then he said at the bottom, assessing whether JPM holds directly or indirectly more than 50% of Viva's voting shares, and or 2, JPM owns or controls more than 50% of the equity of Viva, depend only on the question of whether the additional shares of Viva that JPM may acquire under the call option should be taken into account when calculating the relevant threshold, and do not require consideration of other potential indicia of control by Viva. Then at 167, Mr. Newell's evidence was not challenged in cross-examination. And then at 174 to 176, the judge essentially says there's no need to consider the other routes by which one could establish or that one might conclude that Viva is a subsidiary, because the equity limb of the control test is satisfied, and therefore the court should so decide and indeed declare. So, in this case, by virtue of JPM's call options over WRL shares in Viva, it's possible to identify that Viva is a subsidiary of JPM by operation of what is a bright line legal test that is set out in terms in the regulation. The question whether Viva is a subsidiary of JP Morgan therefore depended in this case on the application of a clear and simple
Well,
test.
the judge decided that Viva is a subsidiary.
Indeed.
That conclusion is not challenged.
Indeed.
So from your perspective, what does the declaration bring to the party? You've got a finding of fact, and it's not challenged, so that finding of fact is binding as between the two shareholders. What extra value do you get from the declaration?
Well, I'll come to the utility of the declaration in a moment, my lord. But I need to show you the pleadings to show what was in issue in terms of the dispute. But it does serve a useful purpose. The court. This was a hard-fought issue. We had expert evidence from 2 experts taking a chunk of the trial. It's a live issue. I'll show you the pleadings in a moment. And having decided the question, there's every utility in the court making clear what is found in its order. I'll come to that in a moment. But the point I was on, my lord, was to echo the point that you, my lord, Lord Justice Lewison, made yesterday, that the judge was interpreting a US legal instrument with the assistance of expert evidence. And it's obvious that Viva is a subsidiary of JP Morgan for the purpose of Regulation K, and there is nothing anywhere in Regulation K to say that you're only a subsidiary if and when the Fed says that you are. Mr. Lissak's second headline point was that the reason why a party is only a subsidiary when the Fed says it is because answering the question involves a regulatory evaluation that can only properly be undertaken by the specialist foreign regulator, the Fed. Not so, as I've just explained. The question in this case did not require any regulatory evaluation. It required the application of a straightforward bright line test, as we have just seen. Mr. Lissak's third headline point was that the judge granted a declaration on a matter which lies within the exclusive jurisdiction and discretion of the specialist regulator. Neither proposition is correct. Mr. Lissak accepted yesterday and again this morning that the question whether an entity is a subsidiary would be justiciable in the US courts. And there was no discretion potentially in play here as regards the application of the equity limb of the definition on which the judge based her conclusion. Mr. Lissak's fourth headline point was that the declaration served no useful purpose as the ruling could not bind Viva or determine its status authoritatively. That headline point is also wrong for reasons which I will come on to develop. Mr. Lissak's fifth headline point was that the judge's declaration as between Viva's two shareholders set up a conflict with the position under US law, whereby Viva is not and was not a subsidiary unless and until the Fed says otherwise. The point is misconceived for the reason I already given under headline point 1. Mr. Lissak's sixth headline point was that the judge's decision on the valuation issue, now ground 1 of our appeal, rendered the declaration irrelevant. This point is just another way of dressing up his fourth point on utility, to which I'm coming, and it falls away on its own terms if your lordships are with JP Morgan on its ground 1 of its appeal. Now, coming back to this ground of appeal put forward by WRL, the starting point is that the judge correctly directed herself as to the relevant legal principles, and Mr. Lissak accepted that in terms yesterday, and we saw that at paragraph 27 of the judgment, the judge correctly identified the Rolls-Royce principles.
Yeah.
And in her ruling on declarations, which we also saw yesterday, which is a supplementary bundle tab, tab 36. Perhaps you also want to remind yourselves of this. This is page 297 of the supplementary bundle.
297, these are her rulings on declaration.
Yes, this is the supplementary bundle. Tab 29, tab 36, I'm sorry, page 297.
Yeah.
The judge quoted from the decision of Mrs. Justice Cockrell in the BNP Paribas and Tratamento Rifiuti Metropolitani, I can get those words out, case. And one sees that the prime purpose is to do justice in a particular case, and the emphasis is laid on whether the grant of declaratory relief is the most effective way of resolving the issues that are raised. Now, the question of whether it's appropriate to grant declaratory relief is obviously fact sensitive, depends on all the circumstances, and it is, as I've already said, a matter of discretion. It's a question on which different judges might reasonably take different views, but it is preeminently a question for the trial judge, and with respect, not for the Court of Appeal. The judge also specifically addressed the question of whether it was appropriate to grant declaratory relief in relation to the question of whether Viva is a subsidiary of JP Morgan for Regulation K purposes. And we have that in the judgment of paragraph 176, page 220 of the bundle. And your lordships were also taken to paragraph 125b of the judgment yesterday by Mr. Lissak. Very fairly drew your attention to that, and I'll be coming back to 125b shortly.
The judge doesn't say it, but I mean, I suppose that what she had in mind in relation to the point about the absence of Viva was, was it the case, she'd be thinking, that all the arguments that could have been put were put? Or is there any suggestion that Viva would have had some further and better argument that might have led to a different result? And that the answer to that was no, because we realised at WRL that had basically run every point that could conceivably be run by Viva.
Yeah. Well, I've got some documents to show you about Viva's position, which your lordships might find of interest.
Right.
We're coming to those.
When the judge says at 176 that it is a dispute between the shareholders, what is? I mean, we know there is a dispute between the shareholders. How is the issue that is the dispute identified? Is it you said
Is in the pleadings.
you said it is because it's a Part 8 claim form, right?
There's a Part 7 and a Part 8, in fact. So there's a full set of pleadings.
Is it it's a pleaded issue?
Yeah, I'm going to show you the pleadings.
Okay.
Yeah, I'm going to come to that.
So jumping ahead, Mr. Anderson.
Sorry.
We're jumping ahead.
No, I'm happy to answer whatever questions your lordships have, of course. Now, the judge, as we've just seen, rightly said it was a matter in dispute, and she also said that although Viva was affected by the issue and not before the court, the matter was fully considered by the experts, as my Lord the Chancellor just put to me. Now, there can be no question but that this issue of law, and indeed the implications for it for the shareholders agreement and the rights and obligations of the shareholder agreement, were in issue between the parties. And can I just take you, please, to the pleading so that you can see this? Can we go, please, to the amended particulars of claim, first of all, tab 8A 3.
In the core.
Core one, sorry. Yes, everything else can be put away.
Yeah.
So the amended particulars, I'm just going to identify the shape of the document and then we'll come to the relevant passages. So section A, introduction. Section B, page 275, summary of JP Morgan's claim. Then section C, bottom of 278, call options and agreed valuation methodology. And then section D, page 286, we come to Reg K. So you can see, just looking at 24, as Nedge Corp, JP Morgan is subject to Reg K. Among other things, Reg K places restrictions and limits on US banks as regards their investments in foreign companies and the activities of their international foreign business in the US. And then under 26, you can see that the pleading identifies the US activity restrictions, so those
It's 29, isn't it?
yeah, just coming to that, but just shows we pleaded out in sort of high level terms the US activity restrictions in 26.1, the non-US activity restrictions in 26.2, and the non-US permissible activities in 26.3, just citing the various bits of Regulation K, various sections. Then 29, as my Lord says, important paragraph. And then 31, US activity restrictions and the non-US activity restrictions therefore apply to and constrain Viva's activities and investments. And then 32, the SPA and the SHA contemplate that Viva would be subject to regulatory restrictions, including Regulation K, as a result of being part owned by and a subsidiary of JP Morgan. And then you'll see among a number of things are referenced there, but if you look at 32.5, I draw your specific attention to 32.5a and b. You've seen these provisions before.
Yeah.
So your lordships have the point, but just to make it, just to reiterate it, that those provisions you've just read, whether they bite or not, would depend upon whether Viva is within Regulation K.
Yep.
Then can I take you to the relief, page 3?
Is that correct, Mr. Heaviside?
Uh,
Schedule 15, paragraph 3, which is quoted at 32.5b.
Sorry, I can't just go back, I've lost my page.
Look, 290.
Thank you. Yes,
Each
sorry.
shareholder shall procure, the company shall not engage in any activities that JPM has notified
Yep.
are not permissible activities for JPM to engage in directly due to its obligations under the BHC Act. The judge
Yes.
listens to the argument about whether Regulation K applied directly to Viva, but she said that because both sides accept that Schedule 15, paragraph 3 was a contractual restriction on Viva, she didn't need to answer the question whether the regulation applied directly to Viva, and declined to do so. Now,
Yes.
where in Schedule 15, paragraph 3 is there anything to do with whether Viva is or is not a subsidiary if JPM notifies that it cannot do something, then the company has agreed not to do it. Well, the shareholders have agreed that the company won't do it.
Well, can I show you? Can I show you what was pleaded back to this one?
Right.
And I hope that will answer the question.
You're going to show us the relief.
Yes, the relief on page 307. So the relief we sought, the declaration that we pleaded in relation to Red K is the one at 64.1. And we didn't get that declaration. We had the cut down declaration that we're now debating.
Yeah.
So that's what was in the particulars. Then can we go please to the defence at page 317? Paragraph 46.2 on page 331. JPM is required strictly to prove that Viva is a subsidiary for the purposes of Reg K.
Yep.
Then 48.2. Not admitted, same non-admission again. And then 48.3, which I hope answers my Lord Justice Lewison's question to me a moment ago. If, which is not admitted, Viva is a subsidiary of JP Morgan for the purposes of Regulation K, then it is admitted that the US activity restrictions set out under section 211(6) of Reg K, etc., would apply to JPM's activities directly or indirectly. For the purposes of Reg K, JPM indirectly engages in Viva's activities, and then by reason of paragraph 3, part B to section 58, Viva would owe.
So putting it in simple terms, it's an admission that if it was a subsidiary, then the effect of paragraph 3 of Schedule 15
would
is
be
that Viva can't engage in any activities which would put JPM in breach of the
Yeah.
regulation.
Yeah, exactly.
That's the point.
Exactly. And actually, if you go back to the, I mean, although they plead there specifically by reference to Viva, if you go back to the 290, I think it was, you'll remember that the relevant compliance obligations in 32.5A and B impose obligations on WRL as well. Each shareholder shall, and it must be implicit in their non-admission in 40, the way they pleaded 48.3, that whether those whether they would be under obligations under those regulatory provisions in relation to Reg K also turns on whether Viva is a subsidiary for the purposes of Reg K.
I don't understand. I find that difficult to square with the language of Schedule 15, paragraph 3, which doesn't seem to depend on Viva having any particular status. It just says if JPM have notified Viva that JPM, can't do something, then the shareholders have agreed that
Well, you
the
need to
company won't do it.
you need to, with respect, Roy, you need to read to the end of 48.3. It becomes apparent. Paragraph 48.3 on page 332, the defence. If you read to the end of that paragraph, you'll see what they say at the top of page 333.
Yeah, it's an admission that in those circumstances that Viva owed a contractual obligation to JPM not to engage in the activities which are not permitted under Regulation K.
Yeah, exactly. So there was, in short, a dispute as to a legal right or obligation. Were they under an obligation? Were Viva under obligation under these provisions? And that turned on whether, in their case, Viva was a subsidiary. So there was a live dispute between the parties in relation to the existence of that legal right and the extent of any obligations owed by Viva and WRL under those provisions insofar as they relate to Regulation K. Can we go on page to paragraph 50.5, page 334.
Sorry, which page?
Page 334, please, my lord, paragraph 50.5. Where they plead back to 32.5. Then can I show you please paragraph 60.1 on page 339. And then can I take you to the relief section on page 356 and ask your lordships please to read 116.1 through to 116.4.
Yeah.
So 116.4 is of interest. The parties will be assisted by declarations as to how the regulation applies to Viva, if at all, on their own pleaded case. And then they say these are matters which WR will address in the counterclaim, and the counterclaim was still being threatened with. Paragraph 3 of their skeleton on this appeal, on their appeal. It's an attempt to throw mud, for want of a more elegant expression, but you'll see at the end, they reserve their right to bring a counterclaim. And one wonders, in circumstances where the court made a decision on Reg K, there was no appeal against the judge's decision that Reg K was going to be included in the trial. They didn't appeal that case management decision. They fought the issue, they lost it. Why are they so bothered about a regulation which they say is of no utility, has no effect, and as we'll see in a minute, is written in water? It's quite bemusing. But the fact is, their own pleaded case is the complete opposite of what Mr. Lissac has been submitting over the last few hours. And then, as Mr. Lissac showed you yesterday, in the judge, in her judgment, at 125B, or on page 212,
125.
B, page 212, the judge made the point that private rights were in issue here, as indeed they were, as I've just shown you. So the issue loomed large across the pleadings, as you've seen. Both parties adduced expert evidence. Much of the court's time at trial was dedicated to hearing cross-examination of the experts. The question whether Viva is a subsidiary was fully argued, and it is relevant, and I'll come back to this, to note it was fully argued against the background of expert evidence, independent expert evidence on both sides. So it wasn't just a question of people lobbing in arguments. We had experts with all their professional obligations to the court, giving their expert opinions on the interpretation of the regulation. The judge made clear findings that Viva is a subsidiary. You've seen judgment 161 to 175, and that conclusion by the judge and her declaration resolves the question of whether the compliance undertakings we just saw in the pleadings are engaged in principle by virtue of the fact that Viva is a subsidiary of JP Morgan for the purposes of Reg K. WRL does not suggest that the judge's findings to US law was wrong, and as you've seen, they didn't even challenge the evidence of JPM's expert in cross-examination on the central question as to the meaning of equity in the definition of subsidiary. My lords, can I come to utility?
Mm-hmm.
Well, in a sense, I've already dealt with a large part of utility because I've shown you the issues, the pleadings, the point about the implications it had for the parties' obligations under the shareholders' agreement. The way in which WRL's challenge to utility declaration has always been advanced until about an hour ago was that if our appeal in relation to ground 1 succeeds, then their utility point falls away. Mr. Lissack accepted that in terms yesterday, day 2, page 147, that if the valuers were prohibited from taking into account regulation K, then it would be necessary, if they were permitted, I'm so sorry, if the valuers were permitted to take into regulation K, then it would be necessary for them to know whether and how Reg K applied to Viva. That's what he told you yesterday. Today we have a different case, apparently. And as to that, we simply say, in response to the points that he made this morning, that if we succeed, the declaration will still inform the valuers as to the restrictions to which buyers may not be subject. In other words, it will help inform the valuers as to the activities which other buyers not caught by Regulation K might be able to pursue.
Sorry, you're going to have to unpack that for me, certainly.
At the moment, the business is, well, Viva is a subsidiary of for Reg K purposes, and therefore it's subject to Reg K restrictions.
Yes.
If we win and the valuers are not required to ignore Regulation K, they can take Regulation K into account, which is the opposite of the declaration which they obtained below.
But hang on, if the valuers are tasked of valuing the shares in Viva on an open market sale basis,
Yeah.
The point that I think is made against you is, why does it matter what status Viva has at the moment, in the sense that if the valuers are looking at the open market, they would be looking at some people who would fall subject to Regulation K and some people who wouldn't, and they might value the company differently on those two different bases with a hypothetical group of purchasers.
But
Why does it matter what the current status of Viva is in circumstances where, if you're right, the financial projections are based upon the current activities of Viva? As a matter of fact, you've got what they are now and what they will project to be over the next 3 years, which, because you have a right of veto, won't include operations in the US. So, in a sense, Mr. Lissack's point is this current status of subsidiary is actually irrelevant.
Well, our answer is that it will enable the valuer to understand what it is that Viva is currently unable to do, but which it will be able to do in the future, which may be relevant to the valuer's assessment of the premium. Because that case is the reason why the business isn't doing these things at the moment is because of Reg K. Remember that under 3.8 they may want to put
But
some further information.
you don't disagree with that, do you? Because you say it is subject to Reg K.
Yes, but when the valuer is looking at what premium might be payable on the open market value, what additional premium to reflect activities.
Well, that will depend upon who buys it, and the value will just it'll be either buyer A, which you hypothesize is wouldn't be subject to Regulation K, and buyer B, who would be, and you just value the company accordingly.
Well, our point simply, there's a short point. Our point simply is that the valuer will be assisted, potentially knowing what it is that the company can't do now that it will be able to do in the future.
Well, the valuer can read the judgment.
Yeah, yes, that's true. And one can say that about any case in which a declaration has ever been granted. That can't be the test, with respect.
Well, no, but the mere fact that I thought that the question of whether to grant a declaration is it's not answered simply by saying there are findings of fact in the judgment, ergo you get a declaration.
No.
So, I mean, if the valuer thinks it's relevant to know what the current status is, he can read the judgment. You say the business is constrained currently by Regulation K.
Yes.
They say the business is currently constrained by your view of Regulation K because you won't agree to doing anything else. And the valuer hypothesises in an open market buyers who would be and buyers who wouldn't be subject to Regulation K. But what's wrong with that? That's the argument you're facing, I think.
So one of the points you made, I'm not sure.
Sorry,
I've
I wrapped up too many.
Yes.
That was like a
Can
today
I-
programme question. Sorry.
Can I invite my lord just to
Yeah, you see now I can't remember. Why we need live note. Let me try and break it down. A valuer can read the judgment.
yes,
And can read the findings of fact as to the current status of Viva,
yes,
which you say is subject to Regulation K.
yes,
WRL says whether it agrees or not, the current business is in practical terms constrained because you take the view it is subject to Regulation K and you won't agree to a business plan which you say would infringe Regulation K so far as you're concerned. So in a sense the parties are ad idem as to why the current business is constrained.
yes,
You don't need a declaration for the valuer to understand that state of play. If you go into what is an open market valuation, by definition what the valuer is doing is postulating two types of buyers in the open market, one of whom would be constrained and one who wouldn't.
yes,
The valuer doesn't need to know the current status any more about the current status to postulate those two types of open market buyers. So what's wrong with any of that for the purposes of conducting the call option, which is what this dispute is actually all about?
because when the valuer is comparing constrained and unconstrained, you have to know what the constraints are.
Yeah, but you don't. But that you can get that by looking at what a Regulation K. You have to hypothesize
Yes,
a Regulation K constrained buyer. That isn't you. Not as far as an open market sale is concerned.
you start with the projections which are on our case based upon the business as it is and as it is currently projected, which means subject to Regulation K.
Correct. And currently, they agree because you haven't agreed to anything which isn't constrained.
Yes, so that's the current position. When the valuer is doing the open market valuation, as we discussed a day or two ago, they may have regard in the exercise of their judgment to premium which an unconstrained buyer might put on the business to reflect untapped potential. And all we're saying is, simple proposition, other right, what we're saying is that in order for the valuer to consider that question, it's helpful for them to understand what the constraints are.
But why does the declaration help in determining what the constraints are? 'Cause as my lord says,
makes plain on the face of the judge's order.
paragraph 176 of the judgment makes it absolutely plain that, as between the shareholders, Viva is a subsidiary, and therefore, for the reasons you've set out by reference to WRL's own pleaded case,
Yeah.
Viva's directly or indirectly subject to Regulation K. That's all the valuer needs to know, isn't it?
Well, the value.
So if another Edge Act corporation is postulated as a potential purchaser, the same problem arises. But if it's not, then it doesn't.
Well, the valuer shouldn't have to leaf through a very lengthy judgment to pick out the fact that Viva is a subsidiary.
The valuer will be paid a lot of money to do some reading.
The valuer is going to have a lot to do in a short period of time.
Well,
We've been around
this
that one.
judgment will be the least of the concern.
Well, I agree. But I'm coming to
Okay, you've got the point that if the valuer has got the order of the court, then it doesn't require
Yeah.
as much reading as the judgment, but there's not much in it really, Mr. Anderson.
I'd be slightly worried actually if a valuer said, oh, I've just seen that judgment, that's all I need to do, I don't need to read the judgment.
Well,
I mean, the other point is Mr. Lysaght made was he recited something very inelegant of my intervention yesterday. Simply knowing whether it is a subsidiary or not doesn't actually tell you much about the extent and nature of the restrictions in fact.
well, that's with respect not quite right.
But it tells you may be subject to them, but it doesn't actually, of itself, the declaration tells you nothing at all about the practical implications of the restrictions.
Well, depends how far your lordship is pressing that. Can I just take you, please?
Sorry,
No, I was
I'm
about
sort of
to take
putting-
you to this
I'm
service.
putting back to you Mr.
No, no.
Lysaght's points to make sure you answer
It's
them.
very helpful. Can I ask you please to take up the judgment, go to paragraph 157? 57.
Yep.
And so could you read, please? So the question, the important point, maybe I should just preface this before I ask you to read the relevant passage. Regulation K establishes and distinguishes between three different kinds of investment. And you get this from 158. Subsidiaries, joint ventures, and portfolio investments.
Yep.
And the reason it matters into which category an investment falls is that different restrictions apply depending on which category you're in. So in order for the valuers to understand what the restrictions, which restrictions under Regulation K that apply to Viva actually are, they need to know whether Viva is a subsidiary, a joint venture, or a portfolio investment. Now, true it is that the declaration doesn't rehearse, doesn't set out, copy out the terms of Regulation K. But it does tell you, on the face of the order, which category you're in.
But just, can we go back a stage?
Yes.
The judge has decided that Viva is a subsidiary of JPM for the purpose of Regulation K. In itself, that does not mean, does it, that Regulation K is enforceable against Viva. You argued that, and the judge declined to make that finding. She says at paragraph 185, because of the contractual obligation that Viva is constrained by Regulation K. She says it's not necessary to decide for the purpose of the present dispute whether Regulation K applies directly to Viva. So for the future, following this hypothetical sale, there is no finding that an edge company which acquired Viva would, or Viva following its acquisition by an edge company, would be subject itself to Regulation K,
I agree.
absent a contractual provision such as Schedule 15, paragraph 3.
Yes, and we, to be clear, we said to the judge she didn't need to decide this question. We didn't argue it and failed to persuade her on that. That was our position. It didn't really need to be
Yeah.
decided. But where, my lord, does that take us? I'm not sure I'm following your lordship's point. I mean, if an edge corporation buys Viva, it is governed, it is bound by Regulation K.
Yes.
And as I showed you on day one, it cannot carry out activities directly or indirectly that are contrary to that are impermissible under Regulation K.
Any Edge Act corporation
Cannot,
that bought Viva could not conduct these activities,
through a subsidiary, which is a subsidiary for the purposes of Regulation K.
which it would be if it bought
Exactly.
this shareholding,
So the expert,
or the whole lot.
so the expert gets some advice, informs him or herself as to the restrictions which an edge corporation, say constrained, would fall under if it acquired Viva. And he or she takes a view, an opinion, expresses an opinion about what that does to the price that such a company would be prepared to pay. Alternatively, the valuer says there will be lots of companies out there that are not H corporations, and they would therefore not be constrained, directly or indirectly, and they would be prepared to pay this much. Having looked at current figures and projections, knowing that they've been prepared on the basis that under its current ownership, Viva is constrained because your clients take the view it is, and you have not agreed to it doing anything which would put you in breach. So, what piece of the jigsaw does the valuer not have, which that declaration in one line will make complete?
Well, with respect, it's a little unreal to say, well, if you can just read the judgment, so why do you need a declaration? Because that's the thrust of the point as I perceive it. Because that's a point which could be made in every single case.
But you accept that just because a judge makes a finding of fact in a judgment, it doesn't automatically get recorded in a declaration. There still has to be a utility to it.
Well, the question on the authorities, we can maybe go back to Rolls-Royce, is what's the most effective way of resolving the issue? That's the question which the judge, assuming all the other boxes are ticked, namely that both all the arguments have been put and so forth, that's ultimately under the authority the question. What's the most effective way of resolving this?
Yes, but just because the parties, observation could be made that if the parties in this case, were limiting in any way the disputes between them, as opposed to taking every single point that each one could possibly and conceivably take between them, just because the parties choose to take a point between them, or at least in this case a non-admission, doesn't, as it were, then automatically pitchfork the judge into a decision as to how best can I give effect to my resolution of that issue which the parties have chosen to bring before me.
Well, the case against me is the judge, having decided the facts at which there's no complaint and can be no complaint, so having produced her judgment, making this ruling, should have declined to make a declaration because the most effective way for resolving the issue at that point was to send the parties off to ask the Fed. That's the case against me.
Yeah, none of the points that I'm putting to you, incidentally, have anything to do with the Fed.
No, I know.
I really couldn't
I understand that,
put
but
the Fed onto one side completely. I'm just focusing on the dispute between the parties, which is all to do with the working and exercise of the call option.
I accept that is what this dispute about. We have been threatened with wider disputes, but I accept that the dispute between the parties was focused on the call option, but it also included the application of contractual terms and whether they were applicable. As
in
you see.
essence, your point is this was a question of discretion for the judge. Whether a declaration is or isn't useful is an evaluative decision for the judge.
Yeah.
Whether this is the most effective way of resolving the dispute is an evaluative decision for the judge, and we shouldn't interfere with it.
Yes. Yes.
Which one you could sit down?
Wishful thinking, I'm afraid, my lord.
Yeah, the interventions over the last 10 minutes have been because you haven't been content simply to rest there.
Well, I'm trying to. I need to give you our counter arguments if your lordships aren't with us on that fundamental point. I've referenced the discretionary nature of the decision and so forth. But if you're not with me on that, then you need to know what we say about the points they make, which is why I'm doing this.
Okay.
Could I just have a moment, please, Melissa? Anything else I need to pick up on this? Yes, can I just add this point? Yes, I don't need to make that point. Right, I'm going to move on to the second point made by WRL, which is the point that the declaration should not have been granted in the absence of Viva. The starting point is that there is no rule that all parties that are potentially affected by a declaration need to be parties to the proceedings. You've seen the reference in Rolls-Royce, paragraph 120 sub 6. Happy to go back to it, but I'm sure it's familiar territory. The court must ensure that all those affected are either before it or will have their arguments put before the court. The suggestion that Viva is prejudiced by the fact that it was not formally joined as a party to the proceedings is, in our respectful submission, unreal. As the judge correctly observed, paragraph 176 of the judgment, the question has been fully considered by independent experts, so all arguments were put. Tellingly, WRL has not identified any argument that Viva might have advanced if it had been party to the proceedings, but which was not advanced by WRL. And that's unsurprising. Both Viva and WRL are represented by the same firm of solicitors. Mr. Coronis is both the majority owner and controller of WRL, and he's also the CEO of Viva. The origin of the Regulation K dispute lies in correspondence sent by Quinn Emanuel on behalf of Viva and WRL in December 2023, and you do respect need to just see it in this. Can I take the supplemental tab 4, page 39. So this is a letter sent on the 22nd of December 2020.
Sorry, can you give me a page reference?
Yes, page 39, my lord.
39.
It's a supplemental bundle.
Yeah.
So letter sent by Quinn Emanuel, 22nd December 2023. I want you to note the writer's email addresses, significance of which will become apparent in a moment. Paragraph 1, we write on behalf of Viva. The purpose of the letter is to identify the ways in which your client's position on Reg K is wrong and consequences which are that Viva has failed to take advantage of opportunity in the US market and to invite your client that it will desist.
So which paragraph?
Paragraph 2, I'm sorry, my lord. Of the letter.
Yeah.
And then I'm going to come back to this letter, but for present purposes, can I just ask you to read paragraph 42 on page 51?
Sorry, which paragraph?
42, please.
42.
Page 51, yeah. The point there is that the essence of this letter was the complaint was being made that various activities and investments which JPM was saying were restricted under Regulation K were not in fact restricted under Regulation K. That was the thrust of the complaint. Then you go to the next tab, the very next day.
This is a letter sent on behalf of Viva.
No.
The first one, that is.
The first one is Viva, tab 4. Tab 5, next day, letter on behalf of WRL. Same email addresses, same firm, same team.
Yeah.
Adopting Viva's arguments.
Yeah.
And you see that, you look at paragraphs 9 to 13.
Yeah.
Now, indeed, JPM had in fact understood from this correspondence that Viva accepted that it was subject to Regulation K indirectly by virtue of JP Morgan's shareholding and the terms of the shareholders agreement.
Yeah.
And the complaint, we go back to tab 4, the complaint was not as to whether Viva was a subsidiary or was caught by Regulation K. The complaint was as to the extent of the restrictions and whether JP Morgan was adopting a maximalist approach and preventing activities from being undertaken that were in fact permissible under Regulation K. So if we go back to tab 4, paragraph 15, they say the correct position under Reg K is as follows, i.e. implicit within that it applies, but this is what it permits. Paragraph 30, page 47. Again, complaining that the activities that they wanted to carry out were permissible activities for the purposes of Regulation K. Not suggesting Regulation K didn't apply, just saying Regulation K allowed them to do this.
Yep.
And then 34, same point. Perhaps most clearly, last 3 lines on page 48. And first 2 lines of subparagraph B at the top of page 49.
So the dispute wasn't about whether Regulation K applied at this stage. The dispute's about what the extent of the restriction was if it did apply.
Yeah, exactly that. And this, moreover, gets better. This would have been consistent with the terms of the Regulation K policy purportedly adopted by Viva, which proceeded on the express basis that it is a subsidiary of JP Morgan for the purposes of Regulation K. Can we go, please, to tab 1.1?
So what you're doing is simply showing that all the arguments are made.
No,
What exactly?
what I'm showing you is that Viva has always accepted that it is a subsidiary of JP Morgan for the purposes of Regulation K. So when Mr. Lissack submits to the court, well, the court would have to guess what Viva might have said. There are a whole load of arguments that might have been put. I'm just introducing some reality into that submission.
I think that's okay. That's what I thought I was asking you, but obviously
Yes.
not well enough. But right.
Sorry,
Okay,
well,
so-
I misunderstood the question.
1.1 of the second supplement.
Yeah, page 35.1.
What is this?
This is a minute, you can see from the top, minutes of the meeting of the Board of Directors of Viva, dated 16th of December 2022. Top right column,
Page?
page 35.1. The supplementary bundle, my lord.
Yeah.
So minutes of the Board of Directors, you'll see the people there included Mr. Coronis, about a third of it down the page. Agenda item 1, approval of the group policy and procedures ensuring compliance with the provisions of Reg K. The company remains committed to ensuring compliance with Reg K provisions and is hereby adopting a group Reg K policy and procedures as necessary and in accordance with its principles and as provisioned in the sale purchase agreement between the company shareholders and JP Morgan. It is noted that in the application of the Reg K policy and procedures, the company is also taking into consideration the provisions of Greek corporate law on the duties and responsibilities of the Board of Directors regarding the management of information pertaining to corporate matters, as well as its obligations to comply with the laws and regulations applicable to a European financial group, as well as in accordance with its financial licenses. The document setting out the Reg K policy and procedures adopted is attached. The Reg K policy will enter into force upon conclusion of the investment by JP Morgan in the company and will be updated accordingly as per the company's Board of Directors and shareholders' decisions. The Board of members unanimously approved the above and the attached group reg policy. And then we go, please, to 35.5. Reg K policy, Viva Wallet Group. And then we go to page 35.7. Introduction describes the Viva Wallet Group. Second paragraph, the group is active in the financial sector. Third paragraph, as a result of the investment by JP Morgan International Finance in Viva Holdings and each group company are subsidiaries of JPM under, and the group is subject to Regulation K. And then if you look lower down the page under B, key requirements, A, activities outside the United States. Viva Holdings acknowledges that due to JPM being its shareholder, it and any of its subsidiaries are each indirectly subject to Regulation K, and that the groups may engage only in activities that are permissible for Regulation K purposes. Viva. Your lordships are getting the picture. We don't have to guess what Viva would have said in this case, because we know. We've got their policy and we've got their letters they wrote on the eve of the dispute. For some reason, notwithstanding all this,
It would be quite interesting if somebody come along and said, well, actually, that's all wrong.
We might have had some cross-examination.
We might have had some cross-examination about
Yeah.
that, quite. Yeah.
But for whatever reason, notwithstanding all of that, WRL chose not to concede the point in these proceedings and pleaded a non-admission. But even if Viva had also changed its stance to align itself with WRL, WRL can be expected to have run all the arguments.
Well, as a matter of pleading, and what it's proper to plead and not plead, one can see why it was a non-admission rather than a denial.
Well, WRL could, if things were being run independently, they could have their own independent position. But that's a bit tricky given the correspondence that I've shown you, because things were not being run independently at that point in the correspondence, as you've seen. And we do say that in any event, it's wholly unclear how Viva is alleged to have been to be affected and still less prejudiced by the declaration. And if it could be, we say it was incumbent upon WRL to produce evidence at trial about that. And if I could take you please to WRL's trial skeleton, page 229.
This is
Supplemental bundle, sorry.
page.
Page 137, which is tab 26. Sorry, everyone, could you just give me a moment? Just check I've got the right reference.
That's yours.
229,
This will be tab 27.
yes it is. Yes, that's right, tab 29. Sorry, page 229, tab 27.
229.
Yeah. Pick up the very last word on the page of 229. The subsidiary in issue in particular nevertheless has the potential to affect its relationship with other regulators such as Bank of Greece, the FCA and the European Central Bank. So when my Lord Justice Snowden asked Mr. Lissack yesterday whether he was saying that the reason why WRL didn't raise points about Viva's prejudice, whether that was because Viva wasn't there, Mr. Lissack said yes. Well, the answer is they did raise them, but they didn't put any evidence in at all. And they could have done, because it's not right there was no factual evidence at trial. You've already seen Mr. Rees' statement and Mr. Robertson's statement. The context in which the declaration was granted was a private law dispute between JP Morgan and WRL as shareholders in Viva as regards their rights and obligations under an English law governed contract with an exclusive English jurisdiction clause. The declaration does not have any wider application to Viva.
Where are you reading from?
My own notes, my lord.
Sorry?
My own notes, my lord.
Oh, I see, I'm sorry.
The lack of any practical consequences for Viva of the declaration granted by the judge appears to be accepted by by WRL. We look at their skeleton on their appeal, page 88 to 89, paragraph 65.
88.
Yes.
Yeah.
They say at the bottom of 88, the declaration will have no legitimate practical effect or application where the Fed is the exclusive regulator, Regulation K. The finding of the English court that Viva was a subsidiary is a thing writ in water. So we don't understand. They say that there's going to be some big prejudice to Viva. They say the opposite in their skeleton. WRL has...
Well, it begs the question why they're making such a fuss about there being a declaration.
Well, quite. I mean, one has...
However long it is now.
Yeah. Well...
Several hours.
Yes. What's really going on?
Point.
What have they really got in mind?
Well,
We don't know.
that's a thought that's been going through my mind.
No utility, written water, pointless waste of time, but we'll have a morning arguing about it when it's in the judgment. Really?
Particularly in the light of what you showed us in the correspondence before trial.
Right. WRL has relied on 3 cases: London Passenger Transport Board and Moscrop, BNYM and SR, and FSA and Rourke, but none of them assists. Can I take you to them very briefly? In Moscrop, which is Authorities 2, tab 7, sorry, Authorities, tab 2, page 7. So sorry.
Yeah.
The issue was whether an employee could obtain a declaration that a provision of an employment contract that permitted other employees to be accompanied by a representative of a particular trade union was unlawful and void. The critical point is that the claimant employee was not a member of the relevant trade union, so the claimant didn't stand to gain anything himself from the action. All that he might achieve would be to obtain a finding that other employees who were members of that trade union had no contractual right to be accompanied. Okay, we go please to the speech of Viscount Morn on page 19. Just picking it up at the second paragraph break in the middle of the page. My lords, I cannot call to mind any action for a declaration in which, as in this case, the plaintiff claims no right for himself, but seeks to deprive others of a right which does not interfere with his liberty or his private rights. Obviously not this case. Page 26, Lord Wright, the last paragraph of his speech, picking up the second line, the respondent is not claiming any relief or advantage for himself, and the case is not one in which the court should exercise its discretionary power to make a declaratory judgment. I also agree that the action is not properly constituted in regard to parties. Now, in those circumstances, it's unsurprising that the House of Lords didn't consider the action had been properly constituted. The claimant did not have any interest of his own in the relief sought. Here, by contrast, there is a real dispute between JPM and WRL as to their rights and obligations as shareholders in Viva pursuant to the terms of the SHA, as I've shown you. And it's the effective resolution of that dispute between the parties that is the direct object of the declaration. Next, Bank of New York Mellon, tab 15, page 400. Look at paragraph 3. This was a claim in which the defendant took no part in the proceedings and was not represented. It's a world away from the present case, where two parties represented by large teams of counsel and solicitors in relation to a binary question that admits only of a yes or no answer, is it a subsidiary or not, an independent expert on both sides of the argument. Next, can I go to the Rourke case, tab 6. And this was not a case where an affected party was not before the court. The question was whether the court should grant a declaration that the defendant carried on unauthorised deposit-taking business and had made false statements to various individuals in connection with an application for summary judgment. In other words, should the court make those declarations on a summary judgment basis? That was the issue. And the passage that the WR relies upon is at page 88. Justice to the defendant, justice to the claimant, justice to the defendant, whether the declaration would serve a useful purpose. We don't dispute that as a general proposition. The defendant here is WRL, not Viva. And in any event, we say there is no injustice to Viva in granting the declaration. So that's it on the point about Viva's absence from the trial. Third and finally, what is said to be the exclusive competence of the Fed. WRL makes various arguments on the basis that it is said the question of whether Viva is a subsidiary lies within the exclusive competence of a foreign regulator, the Fed. And indeed, they go so far as to suggest that this is not really a question as to the content or effect of foreign law at all, but rather an exercise in predicting how a foreign regulator will apply its own regulations, and that's what they say in their appeal skeleton at paragraph 65. The premise for this submission is wrong. WRL accepts that the interpretation of Reg K is justiciable before the US courts. The ultimate arbiter of the meaning of Reg K is the US courts, not the Fed. This is no less a question of law as any other exercise in statutory interpretation. It may be true that there's no authority in the US cases on the question, but it's common for the English court to resolve questions of foreign law, including the interpretation of statutes, where there is no judicial decision directly on point. And contrary to the suggestion made in WRL's skeleton, the judges at paragraph 49.3, the judge's approach was entirely orthodox and consistent with the principles in the Byers case, which I won't take you to, but its authorities 19, page 485, para 104. Given that the statute was in English and from a common law legal system, it would have been entirely legitimate for the judge to apply her own legal training to interpret the statute for herself. But as it happens, the judge was guided by the expert evidence, which was not even challenged by WRL in cross-examination on the relevant point. And as you know, WRL does not suggest that the judge's decision was wrong in fact. WRL also relies on two further authorities, Tiva and Milebush. Neither of them are on point. Can I just deal with those quickly? Tiva is an authorities tab 21. Page 522, Lord Justice Arnold framed the issue thus: is it proper for the courts of England and Wales to make a declaration solely for the purposes of influencing a decision of a foreign court on an issue governed by the law of the foreign court? That's obviously world away from this case. At paragraph 28 on page 528, Lord Justice Arnold acknowledges that it's sometimes legitimate for the English court to take account of the spin-off value of a judgment in a foreign court.
Yeah.
But then at 35 on page 531, he contrasts that spin-off value that may be legitimate with the issue in this case. And then at 51 on page 537, he concluded that it's wrong in principle for the English court to make a declaration solely for the purpose of influencing a decision by a foreign court on an issue governed by the law of the foreign court.
Yeah.
But that's not the purpose of the declaration in this case. It's no part of our purpose to influence the Fed or a US court on the subsidiary question.
Yeah.
And then Milebush, tab 10, page 183. In this case, the claimant, Milebush, sought a declaration as to the meaning of a planning obligation made in a Section 106 agreement between the defendant, Tameside, and the local planning authority, Hillingdon. Milebush was not a party to the Section 106 agreement, and under the Town and Country Planning Act 1990, Hillingdon had sole responsibility for enforcing Tameside's obligations under the Section 106 agreement and had a discretion to vary the terms. And in exercising those powers, Hillingdon would act in a sphere of public law in furtherance of planning objectives. Milebush therefore had no private law right enforceable against Tameside or Hillingdon. And the majority of the Court of Appeal, Lord Justices Mummery and Jackson, held that Milebush's attempts to bring a private law claim were illegitimate. One sees this from paragraphs 14 to 16 in the judgment of Lord Justice Mummery. The he in the first line of 14 is the judge below. I invite your Lordship just to read 14 to 16, please. And then, can I ask you please to look at Paris on page 191, 47 to 52, the judgment of Lord Justice Jackson.
47 to
52, please. So we say that in that case was in substance a public law dispute, which should have been brought, if at all, by way of a claim for judicial review against Hillingdon in relation to any decision to enforce or not the Section 106 agreement.
Yeah.
And again, that's nothing like our case. Mybush therefore does not assist WRL. The final point which I need to deal with is the suggestion that the court should not have granted a declaration because JP Morgan could and might already have asked the Fed to determine whether Viva is a subsidiary of JPM for the purposes of Regulation K. This is a bad point, we say, for the first, because this could only be relevant if and insofar as the court took the view that going to the Fed was a more effective way of resolving the issue. The judge, in exercise for discretion, did not so conclude, and she was well within her rights to do so. The starting point for WRL's argument, see paragraph 70.1 of their skeleton, is that it was common ground that JPM simply had, that JPM could have asked the Fed whether Viva is a subsidiary for the purposes of Regulation K. And that's not quite right. It was common ground in the pleadings that anyone could ask the Fed informally, could approach the Fed informally, seeking its view as to whether a particular investment was permitted by Regulation K. And it was also common ground that anyone could make a formal approach to the Fed, seeking an advisory opinion regarding the permissibility of any activity under any part of Regulation K. And can I just quickly make that good? The core bundle, can we go please to the defence at page 329?
329.
Yes, please.
Yeah.
Paragraph 41. Anyone can make an informal approach to the Fed. See that?
Such informal approaches are commonplace.
So they said. We'll see what we said about that in a moment. But that's informal approaches at 41.1. 41.2, a formal approach can be made by any person. And then in the reply, give me a moment. Sorry, I'm just trying to find the reply, which has gone missing in my bundle. Page 377. At 379, you'll see what we said about that in paragraphs 6.1 to 6.3.
What's this got to do with the declaration? These approaches, the pleaded approaches, are not about whether Regulation K applies. It's about what is permitted by Regulation K.
This part of our argument is directed to WRL's argument that the judge was wrong to grant a declaration because JP Morgan
Now,
could
I
have asked
follow,
the Fed.
but this is all on the assumption that Regulation K does apply. There's nobody's saying that you can go to the Fed, or at least not pleaded that you can go to the Fed and ask, does Regulation K apply? What is being said is you can go to the Fed and ask, are certain activities permitted under Regulation K?
Yes.
Which is a different question.
Yes. Well, yes, my lord.
Yeah.
Yeah. Yeah. So the point I just wanted to make was, to the extent you may have got the impression from my own friend Skeleton that only JPM could make any of these approaches, that's wrong. There was a case management conference in this case on the 9th of April 2024, at which the judge ordered an expedited trial and ordered that the US law issues, including the subsidiary question, be included in the list of issues for trial. WRL never sought to appeal that decision. At trial, there was no evidence that anyone could approach the Fed, either formally or informally, in relation to any of the Regulation K issues that were before the court. The parties led expert evidence at trial, and the judge decided the issue of whether Viva was a subsidiary on that basis. The question for the court, having decided the issue, was whether to make the declaration, and we say the court unsurprisingly decided that it should. That was the most effective way to proceed. And if WRL had wished to contend that it would be more effective for the Fed to decide the issue, then it should have pleaded and proved that, and it would needed to have led evidence as to the process, what sort of information would likely be required by the Fed, and whether, contrary to our pleading, the Fed would likely exercise its power to give a formal opinion. They didn't do any of those things. And there was therefore no basis for the judge below to consider that an approach to the Fed would be a more effective way of resolving the dispute. My learned friend submitted this morning, the judge was put in a very difficult position by the comments that I made in closing. You saw the transcript of those. With respect, she wasn't placed in a difficult position at all. The judge had the evidence before her. She decided the points on the basis of the evidence in the usual way. End of story. And so far as the CSI, its confidential supervisory information position is concerned, Freshfields have explained in a letter, which if your lordships are not going to take you to it now, your lordships want to see what Freshfields have said about CSI. It's set out in their letter the 20th of May 2024, supplemental bundle, tab 34, page 289. But the punchline is that any communications by way of ongoing supervisory dialogue between JP Morgan and the Fed regarding its investments in Viva would be confidential supervisory information and could not be disclosed without the consent of the Fed. Those are my submissions, unless I can assist you.
Well, he also makes the point in the letter that institutions have been fined for failing to obtain a waiver from the Fed.
I mean, the only reason the point came up was because of Mr. Lissak's submissions that he made during the trial. You were taken to the statement that I made, but on the previous page in the bundle, what the passage from Mr. Lissak's, can I just see if I can give you the page number? I think it's tab 29 of the supplementary bundle. So page 252. Yeah. So supplementary bundle, tab 29, page 252.
Yep.
And the transcript reference, it's page 110, so bottom left column, line 24.
Sorry, handy side, I can't hear above what's going on outside.
I'm so sorry, my lord.
Page?
Supplementary bundle,
Page 252, which transcript page do you want?
110, line
110.
24,
Yeah,
through to 111, line 20.
right. What is this, closing?
This is Mr. Lissak in his closing submissions, to which I then replied in the extract that you saw earlier.
Yes.
Yeah.
So that's what I was coming back on. End of story.
4 points, if I may reply. One, this is not just all about discretion and exercise of it. My lords, the exercise of discretion and the difficulty in challenging it is well recognised by us and was acknowledged by me in my original submissions earlier on in these proceedings. And I don't resolve from that concession of reality now. But the exercise of discretion has to be by reference to principle. And the principles we submit can be summarised in bullet points as fairness, justice, utility, best route, and the parties heard. And those I lift, obviously, as you know, with no disrespect to the judgments, from the judgments in Rourke and Rolls-Royce in particular. It is not sufficient just to say, as a learned friend seems to do, that, oh, this is an exercise of discretion, and that's the end of the matter, and I can, metaphorically or literally, sit down. That is not right, because if there is no basis for saying that the decision of a discretionary nature made by a court at first instance ousts the jurisdiction of this court to exercise a supervisory or reviewing role of the rightfulness of the decision made. I recognise how high the bar is. Anyone practising for more than 2 minutes would know that. But I do not accept the proposition that it is the end of the matter to say, well, the judge could exercise her discretion. And the question is not, was this a discretionary decision? It is whether the decision made was correct. And in our submission, this court is perfectly well placed, and indeed ideally placed, to look at the decision making that was entered into by the learned judge in the court below and say whether or not you think the exercise of discretion was correctly made or not. Second point is that my learned friend seeks to use the facts as found to ground a declaration. He says that, and these are his words I think accurately, there is every utility in the court making clear what it found. He said that in answer to my Lord Justice Lewison's question, if I may clumsily paraphrase, I didn't have a complete note of it. What do you need the declaration for when you have the findings of fact? My Lord, that is a question that went unanswered as my own friend's submissions continued and sits there unanswered now. So may I provide the answer? The answer is that there isn't one. They don't need the declaration. What makes this perfectly clear is the fact that they can point to the factual findings, as was evident from the exchange between my Lord Justice Snowden and learned friend, as to what a valuer might or might not do as regards being given the judgment and looking at it in its detail and what they get paid and so forth. Remember the
Well, you might turn the point round, which is the point that I made to Mr. Handyside, and say, well, given that you don't challenge the findings of fact, what is it about having the declaration that you're so objecting to that we have to have the equivalent of a day's worth of argument about it?
What we're objecting to is that the mere findings of fact cannot act as bootstraps to pull up the argument for declaratory relief.
Yeah, but what is it about having declaratory relief that you are so objecting to? Because so far as the parties are concerned, it doesn't seem to me it's going to make a blind bit of difference, because you've got the findings of fact which are binding.
Makes a difference in 3 ways. One, as between the parties, it is presumably something worth having, which is why we spent the best part of a week litigating the claim by JP Morgan for declaratory relief. 2, that it makes a difference because it affects Viva's status. 3, it makes a difference because it is a declaration of an in rem position to the world at large, as opposed to being an inter partes private right judgment on questions of detail between 2 shareholders. So there is quite a difference. And when you then look at the second one of those and the status impact, you have the regulatory position of Viva, the Viva bank that is wholly owned by it, and so forth, such as I outlined previously and won't weary you by repeating. So there is plainly more to be added, turning the point around against myself as my Lord does, when accepting that challenge.
Mr. Handyside showed us correspondence in which Viva accepts that it's subject to Regulation K.
Well, my Lord,
Directly or indirectly.
my Lord, that is something which I'm not in a position to address standing here now. But that is not the position that is taken in another sphere, as my friend knows. So in our respectful submission, the answer to the second point is, the point that was put by my learned friend Lord Justice Lewison, that there is no need for the declaration given the findings of fact they have. And most certainly it would be quite wrong, to say because there were findings of fact, in those circumstances it would be right to reflect those in declaratory relief. That's not the right approach.
Yeah.
And the third and last point that we make, subject to anything else that I am reminded to bring your attention to, is this. You were taken to the part of the pleadings. Can I trouble you for one last time, as far as we're concerned, at least, turn to the core bundle and go to page 356.
356.
Please.
Yeah.
and to paragraph 116.4.
Yeah.
Can I just invite you to remind yourselves as to the context for 1164? That 1161 through to 1164 is a waterfall of propositions. It begins with a non-admission of Viva as a subsidiary. It then goes on to countenance if it is. Then engages the phrases US activity restrictions and non-US activity restrictions. Then says no admissions are made as to that. And then says we'll reserve our position to a counterclaim, and these are the key words, as to how the US activity restrictions and the non-US activity restrictions apply to Viva, if at all. So what does those expressions defined in the pleadings mean? If I could invite you please to come back to page 286. is in my learned friend's pleaded case.
Yeah.
And you will see there, picking up, and I need to weary you by reading it all out, in 26.1, 26.2, definition of each of the two phrases. And these are the stages or the consequences of Viva being held to be a subsidiary. They are, as my Lord Justice Snowden pointed out yesterday, and this is repeated in submissions today, not what we're concerned with here. This declaration has nothing to do with that stage. And all it's saying is something that is actually different to and irrelevant to the issue that is currently in play before this. It is just not relevant to point to these paragraphs and say, well, you see, as my learned friend does. The focus here is on a different issue to that in play in this declaration, and irrelevant to the current issue because the court made no declaration as to how the activity restriction should apply now in any event. So the issue is not before you. My lords, I think those are the only 3 points I have to make. Can I just turn around a second?
Yeah, of course.
One other point that I'm helpfully reminded of concerns the CSI, and this is just to complete the loop. I'm going to give you the reference in the supplementary bundle to our letter in response to the one from Freshfields and learned a friend reference to you. We do not accept, and it's plain in correspondence, I'll give you the reference, plain in correspondence that we do not accept that CSI is as they would have it. It is in the supplementary bundle tab 32, page 245. Paragraphs 4 to 9. It's a footnote for later consideration rather than requiring a submission on it now. I may have given you the wrong number. So 265. 265, page 265, sorry.
Page 265.
Yes.
And if there's anything else I can assist you with, my lords, those are our submissions.
Chancellor, my lords, it falls to me to deal with the last item on the agenda, which is the one-shot construction. Now, my lords, I have some submissions to make, obviously, in relation to it. They're, again, matters of construction rather than matters of authority. I'm, of course, conscious of the time, and I'm in the court's hands. I'm quite happy to
proceed if the court will forgive me at a relatively brisk pace. But I thought I would raise that because obviously
Well, how long do you need to make your submissions on the one-shot issue?
well, my lord, I'd hoped to have an hour, but we're not going to be able to accommodate that even
Well,
with
you've
the
got an hour
extended
if we
sitting.
sit till 1 o'clock, and then you can have between 2 o'clock and 2. Then the issue is whether Mr. Handyside has enough time. Sorry, Miss Phelps, I beg your pardon, Miss Phelps. Whether you have enough time to deal with it.
Well, it rather depends how fast Mr. Weeks is going to go, but I think we'd estimated an hour.
Right.
Well, actually, I think we had originally estimated an hour and a quarter, but I would hope to improve on that.
I don't mind. I'm happy to do that.
I don't want to run straight through. You just let him go to 1. Okay, well, what we'll do, because we have been running since 10 o'clock,
Thank you.
is we'll take a short 5-minute break, and I emphasise those words, 5-minute break. We'll start again at 25 past 12 by then, and we'll then go till 1 o'clock, see how we've gone, and then we'll sit at either sit at 1:45 or 2 o'clock. But we really must finish this case today,
Thank you, my lord.
so you're going to have to all tailor your cloth accordingly.
Yes.
All right.
Yes. We'll start cutting.
So we take 25
All
past
right,
9
in
o'clock.
Sorry? Yeah, I will.
Well, I've been there so many times.
Yeah.
There's a hotel there, I really like. It's not very far away. Yeah, so.
Yeah, I think
Yes.
Yeah, I'll go and see.
We should be 210 plus 90. We should be at 3.
Is the court ready? Court rise to fable.
Chancellor, my lords, the one-shot or multi-shot construction issue ultimately concerns whether WRL or JPM has priority concerning their respective call options. WRL says that if the call option fair market value exceeds the reference valuation and JPM exercises its JPM call option, then WRL is bound to accept it and the process is at an end. But if the call option fair market value does not exceed the reference valuation and JPM exercises its option, then WRL would be entitled to accept or reject it. In the next option exercise period, WRL would be free to decide to exercise its option. That is the one-shot construction. It reflects the fact that Mr. Coronis built this company himself 25 years ago from the ground up. His company, WRL, agreed to sell almost half of Viva to JP Morgan with the hope and expectation that it would grow into a business worth at least 5 billion euros. That was the bottom line. If Viva does not reach that valuation, WRL would not be obliged to sell its shares and lose its business, but it may choose to do so. For its part, JP Morgan's position is that provided the call option fair market value does not exceed the reference valuation, then it is entitled to exercise its option in each of the 4 option exercise periods. And by doing so, it blocks WRL from ever exercising its option at all.
Well, it potentially does.
it would, on JP Morgan's case, it would block WRL from exercising its option at all, so long as the value didn't exceed the reference valuation. So as long as the call option fair market value is less than 5 billion euros, JP Morgan can make the offer at the call option fair market value, and the consequence is that when WRL rejects it, WRL is not entitled to exercise its own call option.
Because
Because
JP
that's
Morgan has to have the opportunity to make the next shot.
exactly. So that's the difference. The difference between the two is that we could have called it something different. We called it the one-shot construction. It could have been called the blocking construction, because of what JP Morgan's construction allows is for it to block WRL from ever exercising its call option.
But the
And then-
essential issue between you is what is meant by exercise the option.
Yes.
And you say you exercise the option by serving a notice. Once you've
Yes.
done that, you've exercised it.
Yes.
The judge says, no, that's not right. You don't exercise the option until you've reached the stage of a binding contract for the sale of the shares. And if WRL rejects the option notice, then you haven't reached that stage, and therefore the option has not been exercised, with the consequence that it can be exercised in the next period, and so on.
Yes.
And that's the issue.
Yes. Oh, absolutely, my lord. I apologise for trespassing on the court's patience.
What the judge is focusing on there is the consequences of the exercise of the option rather than the exercise of the option itself.
Well, what I'm doing, my lord.
Because if you exercise, if you're right, the exercise of the option is the serving of a notice,
Yes.
which actually says we're exercising the option.
Yes.
Then you get, that's the exercise of the option.
Sure.
Everything else is the consequences of that. You can either accept it or reject it.
Yes.
If you were to accept it, and then the parties have to actually enter into a share sale agreement, those are all the consequences of the exercise of the option. They're not the exercise of the option itself.
Indeed, my
You
lord.
don't defer the exercise of the option until the final form of contract, it seems to me.
No, my lord, we agree with all of that, and we respectfully agree with my lord, Lord Justice Lewison's pithy, if I may say so, analysis. This comes down to the meaning of the word exercise in paragraph 2.3 of Schedule 1. That's what it turns on. The reason I began as I did is to explain what its consequences are and what the context is. This is a technical issue, but it's one with significant consequences because.
I mean, on your interpretation, as Mr. Handyside points out, JPM are taking the risk that if they don't exercise their option, then WRL can exercise its own option, and JPM doesn't have the comfort of a minimum price. On his interpretation, on the other hand, JPM have got to serve notice in every single option period, even if they don't want to acquire the shares.
Indeed.
Yeah.
Indeed. And my lord, my third point was going to be, just to flag it before I get there, is that commercial common sense and these sort of considerations, well, in whose interest would it be to exercise at any particular time, we say ultimately can't resolve this question because there are too many variables. In each circumstance, one would have to wonder whether JP Morgan or WRL would want to be the buyer, because they may want to be a buyer, they may want to be a seller. It may be the position that neither wants to be buyer or seller, which is why there's Schedule 2, which we've not had to trouble the court with yet in these proceedings, but deals with the situation in which neither party actually wants to buy the other out, and what happens then. And it will depend upon what the valuation would happen to be. And when we're looking at the construction of Schedule 1, one of course is doing it at the start, at the point to which the agreement is made. So one doesn't look and say, well, what is the particular scenarios? We say this is not a commercial common sense case because of the commerciality will depend upon the variables during the valuation exercise and position of respective parties. We say the answer to this construction is in two particular points. The first is that Schedule 1 draws a distinction between, on the one hand, exercise of the option by sending an option exercise notice, and on the other hand, the deemed acceptance or rejection of the offer contained in the notice. That distinction is inconsistent with and irreconcilable with the multi-shot construction. So that distinction is drawn. The learned judge accepted that there are passages in which, or 2 points in particular, where there is use of the terms in that fashion, and the judge concluded that that wouldn't outweigh what she thought was ultimately the correct construction of the contract. The second area, we say, shows what the correct construction is the diagram, which is attached to Schedule 1. And we say that this is one of these relatively unusual cases, but cases there are, and we've referred to two in our skeleton and in the authorities bundle, where there's a very complicated set of interlocking provisions, sufficiently complicated that the parties realised at the time that the way to understand how they worked would be to provide a flowchart. And when one looks at the flowchart, the answer, we say, becomes clear, because the flowchart includes two questions which cannot be asked on the multi-shot construction are consistent with the one-shot construction. And the way that the learned judge dealt with the one which was before her was to conclude that a purposive construction had to be adopted. And we say, with the greatest respect to her, that's not the correct approach. The correct approach is to see whether it is consistent with one construction or the other. We say it's consistent with the one-shot construction. So if I may identify the clause in which, or the paragraph rather, in which the issue arises, it's paragraph 2.3 of Schedule 1, page 523 in the bundle. It's concerned with the JPM option exercise period. The chapeau provides JPM may elect to exercise the JPM call option at the following times by sending the JPM exercise notice in accordance with paragraph 212 below. And it's followed by then 5 sub-paragraphs which concern the different option exercise periods. And after the first one, so not in A, but in B to E, there is a proviso. And the proviso is the same, provided neither the JPM call option nor the WRL call option has been previously exercised in accordance with this Schedule 1. If, as per the chapeau, says it in terms, if as per the chapeau saying it in terms, exercise means sending the JPM exercise notice, then the one-shot construction is correct. However, if the chapeau means the purchase of shares or exercise of substantive right to purchase shares, then the multi-shot construction is correct. We make several points in relation to paragraph 2.3, though we accept, and I should make this clear, we accept that these are all indicators towards what the correct construction ultimately has to be. We're not saying that any single point is dispositive. We're saying that, if I may adopt my Lord Justice Snowden's observation from earlier in this case, we're looking for clues as to what the correct construction should be. We do start, of course, with the fact that it says in terms that electing to exercise the JPM call option at the following times by sending the JPM exercise notice. Then if we look at the provisos, so let's take proviso B as an example. During the option exercise period, commencing on the JPM second option exercise date, provided neither the JPM call option nor the WRL call option has been previously exercised in accordance with this Schedule 1. So the proviso provides. So within that proviso, it says, provided neither the JPM call option has previously been exercised. Well, that's important. We know that if the JPM call option is exercised, it must be for the totality of the JPM company shares.
Well, the other thing which is striking is that if the option's exercised in the first period and accepted, then this is just, nobody's ever going to go anywhere near any of this, because the parties will have moved on to making an agreement for the sale of the shares. So this B, as it were, only really arises in a situation where the option, where in the first option period, there's been a service of a notice followed by a rejection.
Yes. Yes, and
And yet it talks about the exercise has been previously exercised, which points towards the service of the notice as being the exercise of the option.
indeed, my lord, we gratefully adopt that point. That is part of our case. We also say this. We say that there is no circumstance in which one should be considering whether the JPM call option has previously been exercised if exercise the JPM call option means buying the shares. That's what the proviso provides. The proviso says, has the JPM call option previously been exercised? Well, if it's been exercised and JP Morgan have bought the shares, we're not having a valuation period. The experts aren't going to be appointed to do the valuation. It serves no purpose at all. But what it does serve a purpose, and an important purpose, is if the one-shot construction is correct. Because if the one-shot construction is correct, JPM hasn't bought the shares, but it may well have sent the notice. And so what this is saying on the one-shot construction is, if JP Morgan has sent an option exercise notice, it cannot then proceed to exercise its option in the remaining option exercise periods. So that fit with the one-shot construction. My Lord Justice Lewison metaphorically raised a judicial eyebrow when I said that the option had to be exercised for the totality of the shares.
No, I wasn't raising an eyebrow at that. You said the JPM option had to be exercised for the JPM shares, and it's actually the WRL shares.
My lord was very politely pointing out my error, so that's my error. I'm sure my lord would have been ahead of me. If it assists, it's paragraph 4.1 on page 530, which shows that when a call option is exercised, it must be for the totality of the shares. So you can't say, decide to buy 25%, see whether the price increases and buy the rest. So that's our first point and second point on this key clause, paragraph 2.3, is as my Lord the Chancellor observed, well, you have all these option exercise periods which would otherwise never arise, and also we say the notion of the JPM call option being exercised also would never arise on the multi-shot construction. We also point to some other textual clues. One is that it is framed as being JPM may elect to exercise, and then each of the subparagraphs are disjunctive. They are joined by an or that appears at the end of subparagraph D.
Yeah.
Now we say that the notion of election, familiar to lawyers, this is a Freshfields drafted contract together with Davis, Polk and Wardell. That's consistent with having a choice between alternative rights or causes of action and having an opportunity to do something once and for all rather than on multiple different occasions. And that is reinforced by using the term or rather than and, which is what one
Although
would
it is
otherwise.
listed completely under C. 2.3C.
It is, and I think that probably is a typographical error.
Yeah.
But thank you, my lord. We say that if the intention had been for JPM to exercise its call option in each of the following exercise periods, then at the very least the chapeau would say may exercise rather than elect to exercise, and the subparagraphs would have been joined as and. Again, we don't say dispositive, but it is a clue. The other point that we make at this stage is it is framed deliberately by cross-reference to paragraph 2.12. And if one looks at paragraph 2.12, 2.12 says in terms, the JPM call option shall be exercised by JPM sending an irrevocable written exercise notice in accordance with clause 29, which will include the following information. So that says in terms what paragraph 2.3 also provides, which is that the call option is exercised by the sending of the exercise notice. What it doesn't say in 2.12 and doesn't say in 2.3 is the JPM call option is exercised by sending a notice, it being accepted by WRL, or it being accepted by WRL and the shares thereafter being purchased by JPM from WRL. We next look at paragraph 2.5, which again reiterates we say what is so far emerging as clear from 2.3 and 2.12. It provides the date of exercise of the JPM call option is the date on which the JPM exercise notice is sent in accordance with paragraphs 2.3 and 2.12. Again, consistent with the exercise of the call option being sending of the notice, not the purchase of the shares. If the option were being exercised when the shares were sold, one wouldn't expect paragraph 2.5 to read as it does.
No.
One would expect it to say, at a minimum, the date of exercise of the JPM call option is deemed to be the date on which the JPM exercise notice is sent in accordance with paragraphs 2.3 and 2.12. What the drafts people have done instead is say the date of exercise is the date of sending. Now, if we may turn to clauses which highlight what we say is the distinction drawn in Schedule 1 between exercise as meaning sending of the notice and acceptance of the notice. And we say that they are found in 2.6, 2.7, and 4.2. Now 2.6 and 2.7 have to be read together. What they deal with is acceptance of the call option by WRL. This is all in the section of JPM option exercise period. So we're all dealing with how JP Morgan can exercise its call option. 2.6 deals with two different scenarios. One is dealt with by subparagraph A, is the call option fair market value being less than the reference valuation. And the other scenario dealt with is it being equal to or greater than the reference valuation. It says, save with respect to any JPM exercise notice served after the fourth option exercise date, which is, we'll see is dealt with by 2.7. If the JPM call option price during the applicable option exercise period during which JPM exercise notice exercise is sent by A, if it is less than the reference valuation, then WRL shall not be required to, but may at its discretion accept the call option. And WRL may be deemed to have accepted the call option if it doesn't respond in time within 10 business days of receipt. As regards B, with regard to the exercise notice, WRL shall be automatically deemed to accept the JPM call option and shall be required to sell the WRL company shares to JPM for the exit proceeds as set out on the terms as set out in this Schedule 1. Then so we have distinction here. We have the sending of the notice, in effect the making of the offer, and we have the distinction drawn between acceptance, automatic acceptance or deemed acceptance if you fail to respond, and the automatically deemed acceptance in the circumstances where the reference valuation is hit. Even where it's above the reference valuation, it's still structured as being sending of a notice and then automatic deemed acceptance. And in 2.7, the same format is adopted. 2.7 deals with the fourth option exercise period. If the JPM call option is exercised by JPM following the fourth option exercise date during the option exercise period in paragraph 2.3d, that's the fourth one, WRL shall be automatically deemed to accept the call option and shall be required to sell the WRL company shares to JPM for the exit proceeds, which for the avoidance of doubt shall be the call option fair market value on the terms set out in this schedule, regardless of the call option fair market value of the shares at that time or at another time. So we make 2 points in relation to paragraph 2.7. A distinction is being drawn in terms between exercise of the JPM call option and its acceptance. The acceptance is deemed acceptance, but it is acceptance nevertheless between JPM exercising its call option, as shown by the words, if the JPM call option is exercised by JPM following the fourth option exercise date, and its acceptance, as shown by the words, WRL shall be automatically deemed to accept the JPM call option and shall be required to sell the WRL company shares to JPM. second point we make in respect of this paragraph is if exercise meant the completion of the binding contract, then there would be no need to refer to acceptance on the part of WRL at all. Deemed acceptance is only necessary as a concept here because the exercise of the JPM call option is limited to the sending of the JPM exercise notice. Now we recognise that the words "if the JPM call option is exercised by JPM" don't appear in the chapeau to paragraph 2.6. It's a slightly different formulation, but there can't be any sensible distinction between the two. They're both dealing with the same situation, which is the sending of the option exercise notice and its acceptance, rejection, or deemed acceptance. So we say that 2.6 and 2.7 show that there is this distinction being drawn, the distinction which reflects the one-shot construction and is inimical to, contradictory to, the multi-shot construction. We could now look, as we're going through, at paragraph 2.9. This deals with this on the next page, page 525. This deals with the WRL option exercise period. This is the analogue to the paragraph 2.3 for JP Morgan. It provides that WRL may elect to exercise its call option, the WRL call option, during the option exercise period, commencing on the relevant option exercise date by sending the exercise notice in accordance with paragraph 12.2.13. Below, WRL may only exercise WRL call option if JPM has not already exercised the call option in the relevant option exercise period. Now, in this paragraph, well, first of all, this paragraph reflects what is in paragraph 2.3, adopts the same structure. In this paragraph, the term exercise appears 3 times.
And if WRL serve the notice, there's no mechanism for rejection or deemed acceptance.
Indeed.
It brings about a contract for the sale of shares for the... I get very confused between the core market open value and the exit proceeds. It doesn't matter, but the point is that once WRL serves a notice, a contract for the sale of the JPM shares comes into existence.
Indeed.
And so you know that when WRL serves a notice, it has exercised the option. And if you then go back to paragraph 2.3b,
yes,
the proviso is that neither the JPM call option nor the WRL call option has been previously exercised.
yes.
Well, if you're looking at the WRL option, it has been exercised merely by serving a notice.
Yes.
So in that same phrase on the multi-option, the word exercise has 2 quite different meanings.
Yes, indeed, my lord. Indeed, indeed. And we respectfully agree. And the reason why you don't have paragraphs 2.6 and 2.7 appearing in any sort of similar form in this WRL option exercise period section is because there doesn't need to be any mechanism for acceptance because it's automatically accepted. That's the...
It's not automatically accepted. It automatically brings a contract for sale into
Indeed.
existence.
Well, indeed. Yes, yes, yes.
It doesn't require acceptance.
No, no.
If WRL exercise the option,
Yes.
then then a contract comes into being.
Yes, in the rubric of the schedule, though, it might be something which would otherwise be reflected concept of automatic acceptance, because that's what appears at paragraph 2.7.
Yeah.
Where if JPM exercises its call option, it's automatically accepted. So we say in relation to paragraph 2.9 that this paragraph also on the multi-shot construction has a defect, which is that it requires, even within itself, the word exercise to be given different meanings. That is because of the words at the end in the relevant option exercise period. In the relevant option exercise period are words that are completely unnecessary if the term exercise means, as JP Morgan would say, the sale or purchase of the shares. If the meaning of exercise was sale or purchase of the shares, then it would simply end if JPM has not already exercised the JPM call option. Those words in the relevant option exercise period are superfluous.
Well, it's the same point as I made to you earlier in relation to the JPM call option.
Yes.
That this is all predicated upon them having exercised the option by sending a notice.
Yes.
You're having not accepted it, and then thereafter they're having lost the right to exercise the option, and this gives you the opportunity to
Yes.
exercise your option.
Yes. And that's what we say. That's what this provides, which is that we have the right to exercise our option if JP Morgan has not sent its notice. The learned judge, as regards the inconsistency in paragraph 2.9, accepted it, and that's in paragraphs 350 and 355 of her judgment, as indeed JP Morgan did below. The final paragraph we point to in relation to the distinction between the exercise of the option and the acceptance of the option exercise notice is paragraph 4.2, which is on page 531.
Yeah.
What paragraph 4.2 is dealing with, it's in the section on the previous page headed general, but it's dealing with the mechanics at the end if the option has been exercised. And what is important is the words in the chapeau that appear in parentheses near the beginning. Subject to paragraph 4.3, if either the JPM call option or the WRL call option is exercised, and these are the words which we place particular weight on, and if applicable accepted, in accordance with this Schedule 1, each party shall use all reasonable endeavours to enter into the transfer agreement as soon as reasonably practical, and in any event no later than 10 business days, and so forth. And we make the following points. Firstly, the words if applicable accepted are expressly drawing a distinction between the exercise of the option and its acceptance.
Yeah.
Secondly, the words in the parenthesis indicate that mere exercise of the option is not necessarily sufficient for the shares to be bought or sold. Rather, it may be necessary for the option to be accepted, and it is only then that the parties have an obligation to enter into the transfer agreement for the transfer of the relevant shares. Why does it say if applicable? Well, it says if applicable because in respect of WRL, there's no need for there to be acceptance of the option exercise notice. So it is only something that arises on the JPM option exercise notice. Now, a further point that has to be made in respect of this paragraph is that it also requires, on the multi-shot construction, the word exercise to bear two different meanings. Where the term exercise is used in the first sentence, it must refer to the sending of the exercise notice. Otherwise, the words in parenthesis, if applicable accepted, would make no sense. Yet on the multi-shot construction, where the term exercised appears in subparagraph A, WRL, where the JPM call option has been exercised, on the multi-shot construction, that must mean the exercise of a substantive right to buy the shares, not just the sending of the notice. The learned judge below accepted in paragraph 3.61 of her 361 of her judgment that the word was being used arguably inconsistently or arguably used inconsistently. Her ladyship held it is in fact plainly, with respect to her, plainly inconsistent. Now, we again say this is a further
Well,
clue.
the 4.2a is completely inconsistent with the concept that the exercise of the option isn't, as it were, crystallised until there's an agreement to sell, because it's predicated upon there being an option having been exercised and what the consequences are thereafter. But there wouldn't be a thereafter on the multi-shop case.
Yes, or my lord, yes. Although I think that it would be said by JPM that there are some mechanics that have to be gone through which are actually affecting the transfer after the transfer agreement has been made. So I think they would say that the transfer agreement is dealt with by the chapeau, and then there's a process here, a mechanical process of potentially updating the valuation.
Yeah.
What we rely upon is saying.
Don't think that's quite right, Mr. Weeks. You're quite right to say that 4.2a does envisage an updating process.
Yes.
But 4.2a Roman 2 specifies the price.
Yes.
That tells you what the price is. And the experts go all through all these machinations, and then you ask, well, all right, they've done that. What's the price?
Yes.
And it's 4.2a Roman 2 that tells you what the price is.
Yes. Yes.
And that's necessary, particularly for the exercise by WRL of its shares, because nowhere else can you find what the price is.
Yes, yes, my lord, yes, yes. Yes. And we say that 4.2 as a whole is not something which can be reconciled with the multi-shop construction. It is something which is drawing in terms the distinction between exercise and acceptance. And in order to try and avoid the consequences of it, the multi-shop construction requires the word exercise to be read in two different ways within paragraph 4.2 as well. My lord, that's what I intended to say about the terms in the body. I then want to turn to the diagram. I wonder whether that might be a convenient moment for us to.
Okay.
My lord, just for your lordship's rise, may I just say that with your leave, I won't be here at 2 o'clock. I have a pre-existing commitment of long standing, which is understood by those instructing me, and they're happy I'm not here. I hope my lords are too.
No.
Thank you very much. Thank you.
All rise if able.
2 o'clock.